Good morning, everyone, and thank you very much for the opportunity to participate here today in this discussion on gender equality and specifically this morning on the Constitution and the law in relation to the family. The questions that have been posed to you for discussion and that I'm going to centre on really look at what our constitutional provisions are on the family and how those have impacted on how we regulate and support different kinds of family units in Ireland. The family itself is protected in the Constitution, and you've all been given the text of Article 41, which is this key provision on the family unit. It describes the family as the natural, primary and fundamental unit group of society. And then goes on to talk about the family as a moral institution with inalienable and imprescriptible rights. Now that's quite significant because just looking at the language there, you see that there's this idea of the family unit itself as being antecedent, as being superior to all positive law. So it has this kind of enshrined position within the Constitution. And for many decades, that language and that idea of the family unit is kind of sealed, as protected, as having a certain priority within society and within law. There was concern that that inhibited, that it hindered how we protected those within the family unit. Children, for example, who might be at risk of exploitation or abuse or neglect, situations of domestic violence within the family unit. Could the state intervene? Were there restrictions? What were those? Was this somehow challenging or undermining this position of the family unit? And it took quite some time to get to the situation where we began to recognise that the family is made up of many different units, including children who may be at serious risk, and that the state has an obligation to ensure protection, to ensure equal treatment, to ensure that children within family units or others within family units are also provided with protection. Now, this idea of protecting the family as a fundamental unit is not unique to Ireland or the Irish Constitution. Indeed, if we look at the Universal Declaration of Human Rights, adopted in 1948 in the aftermath of World War II, we see also this reference to the idea of the family as a fundamental group unit in society, entitled to protection by society and the state. So it is something we see in many parts of the world in many legal documents. But it leaves open the question of what kind of family, which families are given protection, how is the family to be defined, what are the limits, what are the priorities, what do we mean when we talk about the family, whether in the Constitution or in legislation or policy measures. And I guess one of the questions that you'll be reflecting on this morning is how much of this should be in the Constitution and how much should we leave to legislation and policy. So, of course, there are many different types of families, and Linda has already raised the questions around the changing nature of family units in Irish society and questions around who comes within the ambit of the family. What about joined or extended families? What about grandparents, cousins? What about dependent others, maybe nephews, nieces, others who end up in a situation of dependency that we might care for? How many of those fit into the family unit that is protected by the Constitution or in legislation? And we know that Ireland has become a much more diverse society. We now recognise and protect different kinds of sexualities and different kinds of relationships. And we're also more diverse in terms of increasing inward migration over the last 2 decades, which again is a significant change in Irish society. Now, in the Constitution itself, the family is not defined. But what we do have in Article 41.3, one is this specific reference to marriage. So the state has committed itself to guarding with special care the institution of marriage, upon which the family is founded. So this is provided for in the Constitution, and the state is given this obligation to protect the institution of marriage against attack. So it's very significant, very strong language here. It's quite defensive in terms of what it's talking about that the state must do in terms of protecting this institution. And that has given rise to much discussion, to case law, to litigation, to questions around policy. When can you intervene in the family? When can you not? What kinds of families are protected? And one of the landmark cases, quite a sad case going back to the 1960s, Nikola and Bort. Nikola was a Cypriot national in London. He had a relationship with Miss Donnelly, who was a young woman from Galway who travelled to London, was working in his cafe, and she became pregnant. She decided to give her child up for adoption and to return to Ireland, and was in a mother and baby home. He didn't know initially about the pregnancy and only found out later when she returned to England, when they did briefly resume their relationship, that she was giving the child up for adoption. And this was without his consent. So he took legal proceedings to try to stop this, to prevent the adoption going ahead without his consent. He wanted to be given the position of guardian of care, to be recognised as the father of the child, and to not have his child going through for adoption. And the proceedings went all the way to the Supreme Court, and the court there was quite clear that as an unmarried father, he didn't have constitutional protection. Those rights that he was claiming couldn't prevent the adoption going ahead without his consent. And the court made a number of important statements that are still relevant today. Although we've had much constitutional change, much legislative change, these statements remain relevant. That the family that was protected in the Constitution is the family founded on marriage. And to give equal protection to an extramarital union, to a relationship that wasn't based on marriage, would not be giving effect to the pledge that is imposed on the state to guard with special care the institution of marriage. So you see the impact of that language on these proceedings and on his position as an unmarried father. Now, since then, there has been significant change. We had litigation to the European Court of Human Rights, where the European Court of Human Rights said that not protecting an unmarried father's right to family life was in violation of the European Convention on Human Rights. We've had legislation abolishing what was known as the status of legitimacy, the discrimination against children born outside of marriage. And of course, we've had a referendum protecting the rights of the child, the best interests of the child, and on marriage equality. So we have had significant change since then, but the Nikola judgment remains relevant today, and I'll come back to that. So looking at some of those changes, marriage equality, already mentioned, the Constitution changed by referendum to allow for recognition of same-sex marriage. Marriage may be contracted in accordance with the law by two persons without distinction as to their sex. So that's a hugely significant change, and it was also hugely significant that it came about by referendum, demonstrating the popular will in favour of this change and recognition of different kinds of relationships. But it's still based on marriage. So again, that's the important point to note. And to give effect to the referendum and to the vote. So the Child and Family Relationships Act gives effect to the reforms from the constitutional referendum itself, and makes significant changes, in particular around guardianship and custody of children. And also, again, the specific commitment to recognising the child's best interests in custody and guardianship proceedings. So that's all being implemented over time. The most recent orders that were just signed were in November 2019, and those won't come into effect until May 2020. And those more recent additional orders starting these pieces of the legislation relate primarily to donor-assisted human reproduction, and again to regulation of the relationships and the family units the rights of the child's right to know their identity. So all of those kinds of relationships are now being regulated through legislation. There is still, however, gaps that remain to be fixed in terms of our legal frameworks. And a very significant case is the McD versus L&M. And this is a case that went all the way to the Supreme Court, and it raised the question of surrogacy arrangements, the position of a sperm donor, and the relationship rights that come from this kind of situation. And here in the relationship arose a man who had been friendly with a lesbian couple, agreed to assist them in conceiving a child, donated sperm, and originally the discussion had been that he wouldn't be directly involved in the upbringing of the child. But that changed after the child was born, and also their friendship broke down. The couple had decided to move, to leave the country, and he brought legal proceedings to prevent that, and also to try to claim guardianship and access to the child that was born. And in the High Court discussion, there was significant discussion around the European Convention on Human Rights and the idea of a de facto family, and recognising and protecting private and family life, and also best interests of the child. The Supreme Court, however, took a different view and decided that the best interests of the child meant that there should be access given to the child on the part of the father, who was the sperm donor, and that the High Court should work out the details of this. But this was, in their view, in the best interests of the child. They also said that the European Convention on Human Rights is subservient to the Constitution. But importantly, in terms of our constitutional position, the court was quite clear that there was no legal institution in Irish law of a de facto family. This was simply not something that was recognised in Irish law in the Constitution itself. So this idea of trying to recognise different kinds of de facto families or units, they said was not something that was recognised in the Constitution. So again, that leaves a lot unclear here. We can look to the best interests of the child. We can look to other parts of the Constitution on personal rights, on the rights of the child, Article 42, which was inserted following referendum, Article 42A. But the Article 41, which specifically relates to the family, remains tied to this idea of marriage. And again, this was reiterated by the Supreme Court in a 2018 judgment, which was a case that involved a lot of questions around immigration. But here again, Chief Justice Clarke made very clear statements that there was consistent case law on Article 41, stretching back decades, so going right back to Nikola, which had been reaffirmed that an unmarried family with children or without children was not a family unit within the meaning of Article 41. So again, it's important to remember that that does not mean that family relationships outside of marriage have no constitutional protection, or that children in those relationships have no constitutional protection. They do, under other provisions of the Constitution. And as I said, that might relate to personal rights or the rights of the child. But Article 41, which is the specific provision on the family, is limited. So again, this is a very clear statement from the Supreme Court, just saying that we have this long history of case law. This is how it is. It stretches back decades. We've had a lot of change, societal, constitutional, legislative change. But the family that is protected in Article 41 is the family based on marriage.